That's okay. I'm looking at what looks like the YouTube screen.
We can see you and we can hear you. You can't see us,
There we
Bob?
go. Excellent.
All right.
Thank you. All right. Good evening, everyone. Welcome to the City of Annapolis Board of Appeals regular meeting for February 4th, 2025. Meeting's being broadcast on the YouTube channel. If you've seen the agenda for tonight's meeting, it contains a link to the YouTube channel and also to the comment form if you need to comment on any of the matters that you'll be hearing about, and also to the city's database. So we'll begin with the roll call. Mr. Consoli, would you mind?
Mr. Gallagher.
Here.
Here. Here.
Here.
All right. Let's see. So we've got a quorum. Have the members of the board had a chance to review the agenda? Any corrections or additions?
I believe there may be a correct.
Yeah, the one on the public website.
Yeah, Mr.
Okay.
Chairman, the one on the public website has under old business status conference of 518 6th Street, but there is no agenda item for 501 6th Street.
My understanding is we're only dealing with 518.
Correct.
So correction,
That's
Mike.
correct.
When I went and looked on the public website today, the only matter listed on the agenda was 501.
Right.
And not 518.
That must be an error.
There is,
Ken,
but we
can you shed any light on that, Ken?
The appellant for 501 6th Street is not available. She's traveling and she requested to be moved to the March 4th meeting. And so the agenda was corrected, but unfortunately not uploaded to the city website.
Okay, that explains it.
Thank
you. All right, so we'll make that correction. Subject to that correction, is there a motion to approve the agenda?
I move the agenda as proposed.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Aye. Thank you. I believe we have one set of minutes tonight. Those would be the minutes of January 7th. Is that right?
Mm-hmm.
Yeah.
Okay. Any corrections or additions to the minutes for January 7th?
No.
No.
Is there a motion?
So move.
Second.
All in favor?
Aye.
Aye.
Thank you. So we only have one case on the agenda tonight.
So Mr. Chair, this is Nadine.
Yep.
As you recall, I need to recuse myself from this case, so I will leave the chambers now.
Yes, I remember that. Thank you for reminding me.
Thank you.
All right, so we're talking about Appeal 24002, 518 6th Street, where the parties are still trying to come to agreement on what constitutes the record. I see for appearances we have Mr. Giel for the appellants, Mr. Fulton for the applicant, and is counsel for the city, Ms. Corrace, with us virtually?
Yes, I'm still here.
Great, thank you. Okay, so let's get right into this. I hope it won't take too long. So we're working on what is the record. And I think we announced in one of our scheduling orders recently that the working definition that we'll use is the record shall comprise the information available to the director at the time the decision being appealed from was made. And of course, relevance or probative value are always issues as well. So, as I see this case, the big issues are whether the director erred in his approval of certain minor modifications that had not previously been approved but were approved in November 2023. That's one issue. The initial site design was back in June 21. And so somebody help me here. Can maybe Mr. Giel, you could tell us, are we talking about one or more modifications that were approved in November 2023 that hadn't been approved previously?
Mr. Chair, first we're talking about the revised plan. We say there are several that
I'm sorry you're breaking up.
yeah, I just saw that flagged above you for a moment. Can you hear me better?
Yes.
Okay. We state first of all that we are challenging several elements of the revised plan in 2023, and we also challenge the director's general. I don't want to inflict words on it. General lack of action with regards to enforcement subsequent to that for matters such as the framing, the height of the property, and everything related to the stop work order that was previously before the Building Board of Appeals. Not specifically the stop work order itself, but that is what we generally alleged in our opening appeal.
All right. Please focus on my question.
I'm sorry.
What modifications do you assert were made and approved in November 2023 that had not been previously approved by the director?
Our assertion is that the floor area of the building was incorrect, that the foundation and general height of the building was incorrect, that there were incorrect calculations with regards to square footage of the attic area. And
all right, let me interrupt you. So you're telling me that the plans, the revised plan approved in November 2023, showed an increase in floor area over anything that had previously been approved?
technically, we would argue that the document submitted in 2023 reduced floor area in a way that wasn't actually the case. And they did so in order to maintain a smaller size under the 3250 rule in the zoning ordinance when the actual documents the actual building was larger than what was written on the plan. But that the director approved that plan with incorrect measurements.
By incorrect measurements, you mean different from what was actually built?
Different from what was actually built and different from what was written in the original plan.
So, but what he approved was smaller than what was written in the original plan.
What he approved has numbers that are written to be smaller than what was in the original plan. There are also writings on the revised plan that we would say demonstrate that that is in fact not the case, and that is a failure to confirm the validity of those measurements, and that is one of the errors that the director made in failing to confirm the accuracy of the plan.
Okay. As to height, are you saying that the director approved an increase in height in November that hadn't been previously?
We're saying that the plan that was the revised plan in 2023 is greater in height than should have been allowed in the zoning ordinance.
And it hadn't been previously approved?
Not the structure. The previous structure that was approved was a different structure than the structure that was approved in 2023.
Was it a different height?
We would allege so. I would definitely think that opposing counsel would say otherwise, but we would allege that it was a different height.
Okay. Okay, so as I see, the issues are whether these were major modifications or minor modifications. And second, a more novel issue is whether the director, in approving the new modifications, had a duty to review and determine whether the aggregation of all of the minor modifications still qualified as a minor modification. So each of you has submitted, getting back to the record, each of you has submitted a list of documents that are at issue as to whether or not they're in the record. And I think we'll just work through them. I invite the other board members to interrupt at any time if you have questions. Now let's start with appellants. So item number 1, Mr. Gill tells us, this is, these are photos, is that right?
No, sir. You might be looking at opposing counsel's argument regarding photos. That is not our item number 1.
Okay, what's your item number 1?
Well, if I may first provide a preamble to the board, with your permission, I don't understand the exact scope of what we are supposed to be discussing tonight. My understanding, based on the prior communications through Ms. Consoli, was that we would be talking about the documents that appellants allege should be part of the record and have not yet been provided to appellants or to the board, which was concurrent to an email in the middle of December wherein the appellants wrote to the Office of Law, and the Office of Law's response was a variety of "this doesn't exist" or "we don't believe that this should be part of the record." The board wrote that well, I guess they were advising Ms. Grace as well, but they wrote specifically that to Mr. Fulton, quote, "To the extent his client objects to any particular item being included in the record, he, like Mr. Gill, must identify the item in writing and briefly state the reason for the objection." My understanding was that we were going to review the email and whether or not particular documents that we say should be part of the record there are or are not in the record. And
That's what we're doing.
well,
And you say number 1 should be part of the record.
well, I say yes, but I don't think that's what we're doing based on the documents submitted by opposing counsel. Documents submitted by opposing counsel are objections to exhibits put in our opening brief, but we haven't submitted those into evidence yet.
All right, let's stick with your list now. Worry about the opposing counsel later.
Okay.
Your
We
number
sub-
1, you describe as plans,
Any
drawings
plans
referred
or
to in
drawings,
the Office of Law letter of October 24th, 21.
Yeah.
What does that have to do with the modifications that were made and approved in November 23?
Well, whenever you're trying to determine whether or not somebody made a decision that was arbitrary or capricious, you're looking not only at what they actually determined, but whether or not they had a knowledge that they were acting in a way that was contrary to the law. And one could conceive of an argument where the director, otherwise doing his due diligence, approved a plan that was otherwise illegal, but that he personally did not act in an arbitrary manner. That good faith interpretation of the director's decisions would therefore mean that he should be entitled administrative deference. The plans and drawings in the letter, as well as the revisions, which I can wrap into the same answer, the revisions 2 and now 6 and 7 of the site plan would potentially evince a design wherein the information presented to the director would have given him the knowledge necessary to know that they were trying to change these numbers in a way that would allow them to circumvent the rules of the zoning ordinance and would give us the ability to review any comments presented in those letters or in those emails, or determine the state of mind of the director such that we could more properly argue that what was approved was not a mere oversight, but an actual deliberate attempt to change these numbers and get this approved contrary to the ordinance, which is a main thrust of our argument. Such is the case that any of the letters and correspondences, any notes, etc., that were in any sort of correspondence between the director or DPZ and the applicant would therefore potentially be relevant to this case. And we don't know if it would be because we don't have the documents.
That's right, and we don't have discovery, so I can't help you with that. So if there's a particular document that you think needs to be part of the record, tell us what it is. But I'm not ordering discovery. We don't have discovery under the board rules.
Well, I don't think you have discovery powers to per se, but you would have the ability to tell the director that the administrative record consists of all documents that were before him, regardless of whether or not they would be relevant to a specific party, and that if those documents exist and somebody, the director simply argues that they shouldn't be included, that shouldn't be a convincing argument to this board.
No, that's backdoor discovery.
I'm sorry, that's what, sir? I couldn't hear you.
That's a backdoor to discovery. I can't help you with that. Let's move on to number 2. So again, it looks like discovery. All applicant requests for modifications. Have you seen the request for modifications approved in November 23 for greater floor area? Well, you said it's for smaller floor area and for greater building height.
I'm not exactly sure you're asking, sir. Could you rephrase your question?
Are there requests that you refer to in number 2
Yes.
that describe the change
You're breaking up, sir.
to
Mr. Chair, I can't understand you. You're breaking up entirely at the moment.
that were first November. Are we still there? My indications are that I've got a good connection.
You're frozen on Zoom.
I noticed that, but the Wi-Fi says I've got.
I can hear him fine now.
Says I've got 3 bars. Okay. All right. So I don't think I got the answer, Mr. Gill, to whether there are specific requests for the change in floor area and building height that were approved in November 23.
Well, I mean, this is part of the frustration that we have with the record, sir. the person who's being challenged is the custodian of these records. And under the Annapolis City Code, he is to maintain permanent records of all of these applications. And in all of my experience in prior administrative and court cases, the record constitutes things including email correspondences between parties. I just worked on a case or am working on a case with a record in Calvert County that is 6,000 pages long and goes back to 2004 and contains every single email correspondence of every single agent that was working on that over the period of 20 years. And if the director's position is that these documents were never asked for in any capacity other than these revisions, then that is one response. But the other response is that they don't believe that it's personally relevant to them, which is how the city responded to several of our inquiries. I can't point to a specific document. All I can say is that to the extent that those documents exist, they would be relevant, and therefore, if they exist, they should be part of the record. And more generally, email correspondences between the board and the applicant and any other member of the community, including complaints from neighbors, including just general observations, those are also part of the record. The record is not determined on a relevance basis. The record is determined on a was it before the director basis. And as a result, you shouldn't be viewing the particular documents requested in terms of specifically how they're relevant to us, although we think they are, which is why we're asking for them, but rather, do they exist? If they exist, they should be included because they were necessarily part of the chain of documents that were before the director. I don't know if I lost him because his screen froze.
I'm going to ask a hypothetical.
Sure.
Let's say we have access to this correspondence back and forth, and the director says, hey, I got your new plans. Looks like you've increased the size. Your square footage is too big. Applicant says, oh, I didn't realize that was going to happen. What do I need to do to get it back into compliance? Well, you need to get it under X square feet.
Mm-hmm.
Oh, okay. The applicant takes the exact same set of plans, changes the dimensions,
Mm-hmm.
and instead of 20 feet, it's now 18. Director looks at that, says, yep, they did what I asked. They did what I don't want to say suggested, but the observation that I conveyed, they complied, therefore I'm going to approve it. Would that constitute collaborative effort to deceive and
Well, I would strongly believe in this circumstance that if I were appellee counsel, I would say that that constitutes good governance and them attempting to bring everything into compliance properly, and that they did their duty, and that they would very gladly like to have such a document in the record to point to and say the director is doing his job. On our end, by itself, I don't think that would be dispositive of anything.
But the documents do show compliance. What was built, you're asserting that was not in compliance, but the documents pertain a compliant.
So the particularities of our argument, and I can get into them, but I don't want to get into them too much before counsel has had the opportunity to fully brief this issue, is that one set of plans has a certain series of numbers describing how big the floors are. Then a separate set of plans has conceptually a floor plan that is identical in terms of actual description, but has different numbers. So either the calculations were wrong between one of these two documents, such that the floor plan didn't change, but the numbers written there did, in which case there was a failure to actually confirm which set of numbers was correct, or the floor changed itself and they didn't actually change the image that was on the plan. Which either way, there's a conflict.
There is conflict, but numbers take precedent over scale. So it would not have been the director's duty to take out a scale ruler and find the conflict. A written number in the AIA standard for engineering and architecture, a written number takes precedent over a scalable dimension. So the director would have relied on the written number, not a wrong scale.
I'm sorry, is that a question or a statement?
I'm asking if it was incorrect. If there was a discrepancy into the scalable footprint versus the written dimension, the director would have relied on the written dimension. Do you agree
I
with
think the
that?
director did rely on the written dimension based on what was before us. Clearly, he approved it. I think that the director would have had an independent responsibility after it was approved to confirm that everything was in fact correct and in accordance with the plan as described, which is one of the other allegations that we put forward. And that there was a failure subsequent.
I'm trying to decide whether the background that led up to the numbers changing, the numbers changed. How they got there.
If the numbers changed and there was a correspondence, hypothetically, as you described, where he talks with the applicant and they say we need to fix this in this particular way, and that's the end of the correspondence, that to me is a very hypothetically beneficial correspondence to the applicant and the appellees generally. That shows everything being totally good, up above board, good proper communications, everything's good to go. If instead we have an email communication where they say, this is actually too big still, but we really want to get it in. And he goes, you know what, I can help you out with that. We'll change these numbers in this way. And that way I'll be able to say it's the right number and I'll be able to rubber stamp it. And then, of course, that would be extremely bad for them. I don't know what those correspondences say because they've never been presented to me. I do know that the way the Office of Law correspondence was described suggests that there is such communication between the director and between the applicant that would shed light on what they actually said to each other.
You don't have to repeat that whole sentence, just that you have reason to believe that that conversation exists?
I have reason to believe that requests to the DPZ for modifications exist outside of the site revision numbers themselves. Beyond the actual official site revision plans, which we also would logically intuit exist simply because of how they were numbered. Like we have to intuit that plan numbers 2, 6, and 7 do exist. 3 and 5, the Office of Law responded to us saying they don't exist along with 2, 6, and 7. Then they said, and I do commend them on this, I'm happy that they did this. They said a week and a half ago or so, actually we found them. And so several months later, after us asking several times, they did find them. We went and reviewed them. We found documents that we will presumably want to introduce in our reply brief or before the board in oral argument. At the moment, that's not in either party's responses. But those plans exist. We expect 2, 6, and 7 to exist based on the numbering system and the fact that revision 8 was the one that ended. And the Office of Law's argument that they were deleted summarily for, I don't know, they just didn't want to keep them. To me, contrary to the requirement in the Annapolis City Code that the director maintain, give me a moment to pull the exact language up, permanent and current records made under the zoning code, including but not limited to all maps, amendments, plan developments, special exceptions, variances, appeals, use permits, and applications in 2108050. We would think those plans exist. Similarly, we think that the requests to the director exist outside of the actual officially submitted revisions, or alternatively, they were the revisions, but they exist based on the language in the letter that was provided to us on October 2021. And I understand the director to say, not director, I'm sorry, the chair to say, we're not going to engage in discovery regarding that letter, but I will still very strenuously note for the record that I don't believe that relevance is important to determining what's in an administrative record. I believe mere existence and access by the challenged authority is what is relevant. If there is a document, regardless of if it's beneficial or detrimental to the moving party, it should be part of the record.
Mr. Keel, so to summarize your argument in larger terms, as the chair said, it seems that you're trying to cast a pretty wide net of discovery that you'd prefer to have. You have the original approved plan. You have the modified plan in November. You don't think the record that's being proposed now by the director would be sufficient enough for this board to take a look at the two and see if there are discrepancies and find without going into, frankly, a lot of alleyways that I'm not so sure we need to go.
I certainly hope you don't have to. We wrote our initial brief with the assumption that we would never get these documents. And I don't expect that any of the board members have read that brief yet. I wouldn't think that they necessarily would have, or even if they had looked at the exhibits that we attached. But our argument was a comparison and analysis of revision 8. There may be nothing in these other plans, but the documents that are in the record show comments and show handwriting marks and show communications in DPZ that, by our argument, lead to a reasonable inference by the director that these numbers were incorrect and that he should have looked into this and that he didn't do his due duty. And if these other revisions have similar markings in them, have similar changes in them that would allow us to point to them and say, this is more evidence in favor of us, then we would point to it. If they instead are exculpatory and they help the appellees, then the appellees would point to it. If they don't help anyone, then neither party points to them at all. They just say, well, revision 6 wasn't the one that was approved and has nothing in it that's relevant. Therefore, we don't look at it. In the same way that there are technically like email correspondences in the record that we won't need to cite to, in the same way that even though the letter in 2021 is part of the record, we don't cite to the letter for any particular proposition with regards to administrative error in the revised plan. It's still part of the record. So the record is large, but the portion of the record that the board would be looking at is the portion that the parties identify as being relevant. Maybe 2, 6, and 7 aren't relevant. Maybe they are. We know they existed at some point. We believe that they either still exist or that they were deleted. And if they were deleted, we believe they were deleted contrary to the requirements in the code to maintain those records. So either we get those documents or we argue that there should be an inference against said documents. I just want to have the documents and confirm that there is something in them.
All right. Do you have anything else, Michael?
No, Mr. Chair, I'm all set for now.
All right. So again, I can't help you with number 2. Let's go on to number 3. Is there still a dispute about number 3?
Number 3 is actually what I was spending the majority of my time arguing about. That's site design plans number 2, 6, and 7. It used to be 2, 3, 5, 6, and 7. The city said all of those were deleted, and then the city said, actually, we found 3 and 5. If they found 3 and 5, I would think that 2, 6, and 7 may still be there. If they didn't find 2, 6, and 7 and it's not there, at the very least, I want a statement from the director saying these documents no longer exist. I don't have any reason to doubt Ms. Carrace's emails to me, but she is not making that specific statement as something that is in the administrative record. On that end, appellees objected that that email shouldn't be considered, which, again, I don't believe. We'll talk about that at a later time. But I think that those site plans were clearly extant, and they are presently not presented to us. And they're part of the administrative record.
Ms. Carrace, do they exist or not?
The director looked and did not find copies of 2, 6, and 7. When he found 3 and 5, we provided them, but 2, 6, and 7 we do not have, which is what I said in my email when council asked me for that.
I don't doubt at all. I think that she was very quick and communicative about that. I don't want to cast negative aspersions on the Office of Law for doing that. I think it was good that they got those documents to us and we reviewed them and we got relevant documents printed out for us.
Okay, so 4, let's take a look at 4 and 5. Comments of Eastport Association.
4 and 5 are documents that exist. The city's argument is simply that they shouldn't be included as part of the administrative record. This isn't even something about discovery or not. Like the Eastport Community Association comments existed. They were presented to the director. They are part of the administrative record. It is all documents that were before him in making his determinations. The city's response that they don't personally believe it to be relevant to the record, I do not believe is the relevant inquiry. I think that the inquiry is, does this exist? Was it before the director? It was, therefore, that document should be part of the administrative record and was not included as part of the record whenever we first reviewed it in August. And same thing with 5.
Yeah, my inclination is this is too far removed from the modifications that we're concerned about that were approved for the first time in November 2023. And my reaction will be the same for plans submitted in August of 2019. So unless my colleagues have a comment on that, I'd be inclined to leave them out of the record. Comments, anyone?
No.
All right, let's move on to 6. What?
I think this one is probably resolved, sir.
Okay, good.
The parties agreed on that. I simply listed it so that the board had the restated list of numbers, but they agreed that enforcement review was part of the record.
Okay. Happy to hear you agree on something. So 7. Is there any limitation on time you were talking about at 7?
I don't know what you mean by limitation on time up until the present between.
I mean, shouldn't if this was
Well, not up
relevant
until the
at all,
present, I should
shouldn't
say.
we be talking about permits that were issued based on the revised on the revisions that were approved in November 23?
Yeah, we would say between 2023 and I guess the time of our appeal, or sometime around that in the summer of 2024, because one of our allegations is the failure to properly confirm all these permitting failures subsequent to the approval of the letter, approval of the site plan. So any permit or lack thereof would be relevant in determining whether or not they complied with the statutory requirements for instance,
All right.
removal
Aren't the
of.
permits a matter of public record?
Well, I mean, I don't think those permits exist. And if we have an agreement that those permits don't exist, then we argue that they were never received. So I would, in my mind, yes, I agree with you that they should be a matter of public record, that they should have been accessible. We haven't found anything, and therefore we should draw the inference that to the extent that any argument we make that is based on this should exist but doesn't, that argument, I want to try to rephrase this. If that document doesn't exist and everyone agrees it doesn't exist, we're going to argue that it should have. So their response to me was that the documents don't exist. The Office of Law just said this isn't a thing.
All right. If they say it doesn't exist and it's not in the public record, I don't know what you want me to do. So let's move on to number 8.
Honestly, I just want to note, because 8 and 9 are going to be the same thing, sir.
Yeah.
All I really want the board to do, if the board and appellants and appellees all agree that the document doesn't exist, is to understand that when appellants argue it doesn't exist and it should, there isn't going to be an argument of actually it does exist, here it is. I want us to deal with the circumstance of this. So actually, we got this particular permit, here it is. If we agree it doesn't exist, all right. But
That's what it sounds like right now. If they find it, it turns up later, we'll have to decide what to do about them. Unless Ms. Corres corrects me, the record and her response is that they don't exist. Is that right, Jessica?
That is correct. Yes. And if that changes, we would advise everybody.
Yeah. Okay. Thank you.
So,
all right.
yeah, I'd say for 7, 8, and 9, then that all of those are wrapped into my response, and then we have an agreement.
Okay. Let's look at the director's comments. Let me get my hands on them here. Okay. 11. What is 11, Jessica?
11 is the trees and demo certificate. And
Right. And from what date?
I'd have to look, but trees are not part of any modification that's part of this appeal. So that's why we objected to that.
They don't have any relevance to expansion of the floor area?
Not that I'm aware of.
If I may be heard briefly, sir. I know I've been speaking a lot.
You have indeed. Briefly is the key word.
Okay. I just repeat what I said previously at the beginning of this, that these are exhibits that have not yet been introduced into the record, and the appellees will have the ability to respond to them in their reply brief, in their brief, and then we will be able to respond in our reply brief. And to the extent that they are introduced into the record in oral argument, then objections would be proper at that time. But I don't believe that your directive via Ms. Consoli a couple weeks ago encompasses objections as to exhibits that have not been formally admitted into the record in the first place.
There aren't any exhibits that aren't part of the record.
Well, I mean, what I'm saying is I've identified documents in my brief that we would want to put forward and say that this is part of the administrative record, but we haven't formally done that. We've put those attached for.
That's what we're supposed to be doing tonight, sir.
If that is the board's decision, then we'll move forward with that.
All right. 11, 12, 13. Tell us about your issues with these items, Jessica, please.
Sure. So record 12 is an exhibit about the record correspondence that I had with counsel. I don't know why that would need to be part of the record.
That was post November 23.
Yes.
All right.
And the certification, which is 13, was also from the director post 2023.
All right.
And also, we also objected to exhibit 8 and 9. Both are from 2024, foundation images and a survey.
Yeah. All right. I find merit to all of those objections. I don't know why they should be part of the record, and they won't be part of the record.
I'm sorry, sir. I have to ask again to be heard with regards to 8 and 9, or at least with regards to 8. I don't have a problem with 12 and 13 because we put that forward to preserve our arguments regarding this particular hearing, just to note that there was an objection as to the scope of the record, and that was the portion of our brief where we talked about that. So to the extent that everyone agrees those emails exist, it doesn't really matter. But Exhibit 8 and also Exhibit 1, because the applicant also argues about this Exhibit 1, the photographs are photographs that the director would have had his personal information available as to what the building looked like at a particular point in time, and that would have impacted his decision making. And to the extent that he didn't take personal images, we think that it is important to be able to at least provide the images of what the house looked like at particular stages in time in a way that the board would understand what the director was seeing at that time. And that's why we think that those documents are relevant. And
I understand your argument. It's a logical argument, but it doesn't carry the day. Okay, let's move on to Mr. Fulton, who's been so patient. He doesn't like number 1 either, but we've already taken care of number 1. Number 8 and 9, he says, were never even received by planning and zoning. Can anyone confirm or deny that?
Mr. Chairman, I'll start with number 9. It's entitled Independent Survey commissioned by Appellants, and it's dated on its face July 2024.
Yeah.
The date of the revised plans in this appeal is November 3rd, 2023. This is patently something that was not before the director when he made any decision that's properly before this board.
Yeah, the date is branded on my brain. Okay, 11, did we talk about 11? We already talked about 11, 12, and 13. So I think we've covered the ground.
Mr. Chair, could I ask as to my understanding of what the board actually considers is the scope of this appeal? Because in our mind and in the appeal that we filed and in the determination that we read with regards to the motion to dismiss, it was our understanding that the board did not agree with the city's argument that the matters of permit compliance and measurement compliance and certification, that is, say, everything after 2023, during 2024 when this was being built, they argued that that wasn't part of the appeal. That was one of our explicitly noted numbers of the appeal, and I didn't see that the board had determined that that was not part of the appeal, and we have submitted documents in relation to that to demonstrate why, subsequent to the approval of the plan, there would have been an independent failure of the director to verify the measurements of this plan. In a hypothetical scenario where the plan was correct, let's say it's completely correct, all the numbers are fine, but the actual building itself was not. Part of our legal argument is that even in that scenario, the director should have noticed that, and he should have made sure that the building as constructed was constructed properly. And some of these documents that we've put forward that we're discussing right now are relevant to that question. We're not putting...
It's a compelling argument that the city sometimes doesn't do as much as some would like to enforce the rules or its rulings or its permits. But that's not something that's left to this board. Our job is to decide whether the director committed error when, in this case, he approved modifications in November 23 that had not been previously approved. And I think, in my mind, there's a broader question. I don't yet know what my colleagues think about in doing that, whether the director has a duty to look back and see what's been approved previously to see whether it all amounts to something more than he would have gotten if the applicant had asked for it all at the same time. And I don't have a view on that, but I think it's an interesting question. Is it any more clear in your mind now, Mr. Gill?
I think it's clear as to what you are presently thinking. I think that this board needs to issue another determination to the extent that any appeal is taken by either party with regards to this board's determination. I do not believe that what you've said here is the same as what was said in the previous denial of the motion to dismiss, because we did duly allege this other matter of failure to comply subsequently, and that count was not dismissed based on our reading of the prior motion to dismiss. And our attempt to challenge it before the Building Board of Appeals was met with a procedural argument that they can't challenge it and that it should be before the Board of Appeals. And then they issued a written decision this month stating that they were not going to make any determinations of fact or make any analysis whatsoever as to the comparative weight of the parties' arguments, and simply say they aren't the party that is capable of reviewing. So if the Building Board of Appeals says they can't review and the Board of Appeals says they can't review, I think that is important for the Board of Appeals to make that statement in a subsequent determination, such that if this does go before the circuit court,
we
the court knows.
We will do that if it's appropriate to do that. What we decided on the motion to dismiss is to agree with you, in part, that claims that there is an extension, in effect, of the claim period where you had no way to know of the decision made by the director. That's what we ruled on the Board of Appeals.
I thank you for clarifying that in the hearing here, sir. I just note the city, because we talked about this after the hearing was concluded, myself and Ms. Carres. We talked about the scope of the motion to dismiss. They specifically argued for particular counts to be dismissed, and that motion to dismiss did not have any statement with regards to those counts being dismissed. And those counts deal with matters that arose in 2024. that we thought were properly before this board. So if there is going to be a renewal of that or clarification from the board or something, I think there needs to be some sort of procedural matter to make that determination outside of the deliberations here.
You'll have a decision that will provide you with your grounds of appeal if that's what you need. All right. So now, where do we go from here? I'd like to hear from each of the council what they think the schedule should be. One thing that is important to the board is that at least a week or 10 days before we have the final hearing, that each member of the board, counsel for the board, and Ms. Consoli get a set of any exhibits that are in the record and that you will rely on at the hearing. So with that, what do each of you have to say about what the schedule should be and what you need? You've already filed quite a bit of paper. What more do you need before we have final arguments on this? Let's start with Mr. Gill.
I don't want to frustrate the schedule here. At the same time, I think that if the board needs to have it 10 days, the only way to do that and to make sure that we have the 20 days in our reply and to make sure that the appellees get the time to file would mean that the appellees would need to file their briefs tomorrow. Maybe not tomorrow, maybe by the end of the week, like Friday, but it would be a very short turnaround for their briefs. And if they can do that, then they will do that if they want to keep it on the 4th. But
where did you get 20 days from?
Your previous scheduling order gave a 30-day window for our opening brief, a 30-day window for their opening brief, then a 20-day window for our reply brief, plus the exhibit pamphlets that you wanted everyone to produce. And then that deadline would have been February 25th, which would have been a roughly 10-day-ish window. I think it was 9 days, but a week and a half-ish window for you to review everything prior to the hearing, which would have been on March 4th. Our extension as to scheduling was done in such a way that we would be able to get all that done within that 10-day window. If we were to have any further extensions beyond this, we wouldn't have that window anymore unless the appellees' briefs were filed immediately. And if they, you'll hear from them next. If they think they can do that, then they can have their stuff filed in the next 2 days. Then we have time to have our reply brief, and we can move forward on March 4th. But if they need more time.
Let's hear from your colleagues. Yeah. Jessica, what's your suggestion? What do you need?
So I would not like to move the March 4th date. This has been going on for a long time. I think that we can likely get, because we already have a appellant's brief, I think we could get something finalized by the 14th. I don't think that there needs to be an excessively long time for appellants to file a reply. I mean, I think that would be not really necessary at this point. And we could get all the documents by the 25th to the board per the prior deadline.
Okay. Mr. Fulton?
Thank you, Mr. Chairman. I've got two items I'd like to address. First is what actually constitutes the record in this appeal. I'll note that this appeal has been going on since July. This is the longest appeal I've ever seen for the appeals.
Your experience is consistent with mine.
I have no reason to believe that the documents prepared and offered by the city are all of the documents that constitute the record in this matter. And as I understand it, those documents come from two places. One is the eTrackIt page for the site design plan project. And the second is the eTrackIt page for the permitting side of this project. When you go into those two eTracket pages, you'll find all the documents that I initially received from the city as the record in this case. And that's pretty consistent with the Office of Law's position, as far as I know, and as long as I've been in this case, that there simply are no other documents that constitute or are part of the record in this appeal. I am unsure of what emails appellants are looking for here, but if they don't exist, they don't exist. And the documents that were considered by the director constitute the extent of the record here.
I believe that's right. I don't think Mr. Gill has convinced us that we need to add anything that's not there.
With that, I will say I'm with Ms. Corres and that I think I can get a responsive brief finalized by the 14th. I don't think another extension is needed here. I respect the board's offering of a reply brief in this case, but again, I find it a bit unusual that they're even afforded that opportunity. I think it's a little inconsistent with past appeals, and I don't think a 20-day period for a reply brief for an appeal before this board is absolutely necessary. I say that because, again, I'll remind the board we've been here for 6 months. I would like to get this appeal done in March. I know that Mr. Hyman, as the applicant and the appellee, can get it done by March, and we're prepared to do so.
Mr. Gallagher, I take objection to the notion that the record constitutes what they described. Site plans 3 and 5 were identified by the city. They are necessarily part of the record. They are also necessarily not digital. That's why we didn't find them. There are documents within those 2 site plans that we reviewed and that we plan to introduce as exhibits, having gotten them subsequent to our filing of a brief. We think that they are going to be relevant to us and our argument, and we were previously granted the ability to have a reply brief. So right now, appellees are essentially saying that they get the additional extension and that we don't get to respond after the board granted us that ability to do so, and we don't get to introduce the documents that everyone agrees are actually still part of the record and existing in site plans 3 and 5 to the extent that we introduce them as exhibits. I'm fine with the 14th. I'm sorry, sir. What?
Let's have your reply brief by the close of business on the 28th. And if you have a problem with...
I have no problem with the 28th. I want to make that clear. I have no problem with that. I can do that in that period of time. My only concern here is that you guys wanted a 10-day window, and now you're going to have a weekend and 2 days to consider everything.
Yeah, I know. But you have to balance that against how long this case has dragged on, mainly because inability of counsel to agree on what's in the record. Anything that's not in the record described by Mr. Fulton, you can refer to it as a proffer.
I understand this, sir, and I will proffer to you. I'll try to get that reply brief to you as soon as possible. I don't want the board to have to spend their time looking at everything over the weekend. So we can get it to you earlier than the 28th, we will do so. And we'll work as fast as possible to submit that within a period of time that gives you that time to look at that.
Good. And now, I think I told you what my view of the issues were here, so I hope you'll focus on that in your reply brief, and I hope counsel for the other parties will also focus on those issues. Either of my colleagues here have any other things they'd like to see addressed specifically in the reply?
I don't think so.
No.
Thank you.
You're good,
Mr.
Michael?
Chairman, I have one thing, if you don't mind.
Sure, go ahead.
There were a variety of items this evening that the board seems to have indicated are not included in the record in this matter. I just want to be clear that these items should not be relied upon in either the appellee's or the appellant's written briefs. I would find it prejudicial to have to respond to arguments reliant upon items which are not properly before the board because they're not included in the record.
Well, you can say that. If he proffers them, they'll be there, and your answer to that is they're not part of the record.
Thank you, Mr. Chairman.
All right. All right, so we're going to stick with March 4th. I guess that's it. Anything else? Good. Good. All right. I thank you all for your patience and your diligence in trying to get this done. I see light at the end of the tunnel. I hope
Mr.
it's not the
Chairman,
train.
Mr. Chairman, I move that we adjourn.
Is there a second? I assume Christian seconded the motion. All in
He did.
favor?
He did.
All right. Thank you all. Thank you all and good night. Thank you, Mark, for struggling with the technology stuff. Thank you, Jessica, Tripp, Mr. Gill.
Thank you.
See you on the 4th. Thank you,
Have a
Kim.
nice night, sir.